Okay, so Andrea, did Howard King fuck up doing this in California?
The only potential good option that I see that might have been an alternative is that, Evan claims she lives in Tennessee now. And often, one of the
Wait a minute, where she's bravely sheltering in her bunker
yes.
with a Navy SEAL team protecting her from Marilyn Manson.
Yes,
No, that's
while
not
showing
true.
her child to the world, her child that's in danger.
Yeah.
But
if that was her defense in court, wouldn't she have to prove if those things actually happened?
I mean, if it's her defense in court, I think it's enough for her to prove simply that she believed that they happened.
Well, she's fucking crazy.
Know?
So I mean, she's so
well,
that's our stand now.
It's all comes down to what is the jury going to think. We've been watching this stuff in our context.
I'm going to kill myself over this case. I'm sorry. I have a concussion. Can I run to California and sue Marilyn Manson for that and be protected by anti-slap? Oh my God. Okay. I'm sorry. Restate that. So I've got everybody's favorite lawyer here, Andrea Burkhart, and she's going to break down the aftermath of this big ruling. And I know it was very disappointing to a number of us, even if it was expected in the Marilyn Manson case. So Andrea, first of all, we've talked about this a lot already, but can you, in like a minute, just summarize for people what this ruling was?
The ruling granted the motions, basically. And so this is a preliminary motion that you get to bring in California when you're alleging that you're being sued for exercising your First Amendment rights, your free speech and petitioning rights. And so Evan Rachel Wood and Ilma Gore had both challenged various aspects of Marilyn Manson's claim against them, based on allegations that they had forged this FBI letter and filed it in Evan Rachel Wood's child custody case, allegations that they had conspired to, gin up this hoax with multiple false accusations of sex crimes and things like that against Marilyn Manson, and then defamation claims accusing him of basically being a pedophile and stuff like that, arising out of this art film groupie that he'd made but never released. And the court basically agreed with Evan Rachel Wood and Ilma Gore that all of those are barred from recovery under California law, under the anti-SLAPP law. They're going to be treated as First Amendment activity, and therefore those aren't going to be allowed to go forward.
And so that leaves what? What is left then in the lawsuit?
So what is left? He still has multiple grounds for a claim that he's filed for intentional infliction of emotional distress, which is basically a cause of action that says you've engaged in conduct that's so extreme and outrageous it exceeds the bounds that ordinary society will tolerate, and you did that, with the intent of distressing this person, and you actually did, cause them severe emotional distress. And so there's grounds for that still survive in this action. Those are things like the swatting, breaking into his email accounts, his social media accounts, trying to implicate him in emailing what appears to be child pornography, that type of thing. So they are very, very serious allegations that still remain. Two of the other causes of action that have survived are specifically claims that arise under the California Penal Code. These are criminal statutes dealing with things like impersonating somebody over the internet, unlawfully accessing their accounts, that type of thing. But it does remove kind of the heart of the case, in the sense that the purpose of this lawsuit, I'm assuming at least to some extent, was to give him an opportunity to litigate the falsity of these multiple accusations that were, so publicly made against him back in February of 2021. Given the nature of this ruling, those claims have basically been taken off the table. And so what's left is this individual wrongdoing that, going to be attributable, to Evan Rachel Wood and Ilma Gore at trial, but isn't going to necessarily touch on those deeper issues of trying to fabricate a Me Too hoax, to nail the guy for publicity and personal gain and political power and all of that.
Okay, so if I understand you correctly, you're saying that there are still significant, legitimate crimes, violations that Ilma Gore and Evan Rachel Wood are accused of in the remaining part of the lawsuit, but it's not going to really offer him an opportunity to publicly adjudicate whether he himself committed those offenses that Evan Rachel Wood accused him of?
That's kind of how I see it, yeah. Because it's really going to, at this point, just come down to, can he prove, they unlawfully got into his computer, used his accounts, called the sheriff's office to do the welfare check, that type of thing. And it really isn't going to implicate that broader conspiracy, that broader hoax. In other words, if you take that hoax out of the picture entirely, it's not going to change the evidence or the perspective on whether they hacked his email. So it really does take a lot of that meat off the table.
Is Evan Rachel Wood implicated enough in what is remaining so that it could still be painful for her to have to, or she could still be found guilty or liable or something if this went to trial? Or is it kind of like, it's basically Ilma Gore and Evan's just kind of now sort of peripherally in here?
Yeah, I mean, that's a great question, and that's going to come down to the evidence. Only Evan Rachel Wood and Ilma Gore really know at this point what the likelihood is going to be that he can make that link. Just based on the allegations itself, it doesn't necessarily look like there's all that much at this point to be able to pin that on Evan Rachel Wood. But remember, these weren't part of the anti-SLAPP suit, and now that the anti-SLAPP decision is out, the discovery stay is lifted, so he now gets to move forward with the process of investigating those claims, things he didn't get to do in any substantial way before.
So he can dig up more evidence, basically.
Yeah, absolutely. And this is how lawsuits typically work. You don't walk into a civil court with all of your evidence. If you had that, you wouldn't need these discovery processes and stuff. So it's perfectly normal that you walk into a lawsuit with some proof. You generally have to have some basis to be making allegations, but it's understood that you aren't necessarily going to be able to back every single thing up that you believe you can prove once you're given the opportunity to go through that discovery process. So that's really what the anti-SLAPP law does, that is so detrimental to justice, quite frankly, in a lot of situations, is it really cuts you off at the knees by putting the standard of proving that you're probably going to be able to win at trial on this issue when you haven't had the opportunity to conduct discovery in it. It changes the standard so that with these types of claims, you really do have to walk into court from the outset with all of your evidence, already obtained and ready to go.
Yeah, and if people have more questions, I want to move on to talking about Marilyn Manson's strategy going forward, and and all his legal strategy up to this point and going forward. But for people who have questions about the anti-SLAPP ruling that we're talking about and don't understand the rationale, look at the previous video that we did together. I'll link to it below. We talked about this because Andrea actually predicted that this was going to be the ruling, and we talked about the motivations for it and so forth. Okay, so Andrea, did Howard King fuck up doing this in California? That's what someone wants to know.
It's a great question. I don't know that he had a lot of choice to do it anywhere but in California. There's grounds you have to establish to show that a court in a particular place has jurisdiction over the wrong itself that you're trying to litigate and the parties that are necessary to adjudicate it. So that's a pretty limited number of places where these types of things can be brought.
So like Johnny Depp, he could go to Virginia with his lawsuit because Amber had written that op-ed in the Washington Post, which is based in Virginia. But like with Evan Rachel Wood, I guess most of her shenanigans have been like in California. What about like going on The View? Like if The View was a New York show or something. I know New York's not much better with the anti-SLAPP stuff, but like if she has appeared on television shows that are based elsewhere, or the companies are based elsewhere, could he do a Johnny Depp and sue elsewhere, or is it kind of?
Well, he could sue elsewhere if his cause of action was arising from that specific act. So if he was suing her for defamation over something he said on The View, then sure, he could probably make an argument that there's a jurisdictional hook to get it into court wherever The View is filmed. That's where the wrong was committed. You know, she went to New York, went on camera and said the things. But the problem is, since that's not what he's suing her for, that's not going to give him that basis. The activities, by and large, appear to have taken place mostly in California. The only potential good option that I see that might have been an alternative is that, you know, Evan claims she lives in Tennessee now. And often, you know, where
she's bravely sheltering in her bunker yes. with a Navy SEAL team protecting her from Marilyn Manson.
Yes,
no, that's not true.
Showing her child to the world. But so where a defendant lives can often be, you know, a valid basis for establishing jurisdiction there. That wouldn't get him jurisdiction over Ilma Gore necessarily. I'm not even sure where she is right now. She was in Florida for a while. So that's a potential implication. But then also being able to still rope in, you know, the fact that the court is being asked to adjudicate all of this stuff that happened probably mostly in California, probably mostly governed by California law. You know, that type of thing just gets a little bit complicated. So no, California is 100% not an ideal forum to be litigating.
Sounds like it's the worst.
Things.
Sounds like you said it was the worst the other day.
Well, you know, it's got the most protective anti-SLAPP statute. There's just really no question about that. And like we've talked about, the implication of that is you just basically don't get to sue people if you're famous for things that people say against you. It's the bar is just so extremely high, and you have to be able to walk into court and prove that somebody actually knew in their mind, actually entertained serious doubts about the truth of what they had to say. You know, how realistic is that as a practical matter? So that's, frankly, from my perspective, that's the cost of doing business in Hollywood. You know, you choose to live in California.
That's why everybody in California is trying to get out.
This is the law you're going to live under.
That's why everybody's trying to get out of California. It's messed up. Just one of the many ways California is messed up. Well, okay, but it's good to know that if I ever want to create a hoax against someone, I just moved to California and I'm golden. So I'm gonna file that away in case this YouTube thing doesn't work out.